So welcome everyone, and welcome to Colin Yeo, barrister at Garden Court Chambers and proud member of MMB, and also the founder of the fantastic Free Movement website, also contributor to it. And Colin has very kindly agreed to talk to us about the upcoming, or not upcoming because it's had its second reading, hasn't it, bill. So I'm sorry that we can't see everyone's faces, but because we have a large number of people attending, we realised we were going to have to do this in webinar format. So Colin's going to talk for 20 to 25 minutes. And then we are going to ask you to put your questions in the Q&A. So please remember, put your questions in the Q&A and not in the chat. I will then put your questions to Colin. If there are too many questions, then I might well have to group them, and we'll just do the best we can. So thanks very much, everyone, and should we get started?
Well, thank you very much, Bridget. Thank you. So I've been going through the bill again. This is the Nationality and Borders Bill. And on the day it was published, CJ and I sort of sat down and frantically sort of started going through it. A journalist had sent an embargoed copy beforehand, so we had a slight head start on some others. And I've been going back through, and the whole process, I have to say, has sort of reinforced the impressions that I had when I was first going through it, which are really that it doesn't feel like a serious piece of legislation in some ways. It is, at the same time, it is really serious in the sense that it is going to have a very negative effect on a lot of vulnerable people. But beyond being horrible to them and essentially punishing them, it won't have public policy sort of impacts. It's unlikely to deal with delays or stop asylum seekers wanting to come to the UK. There aren't really any likely outcomes in public policy terms, frankly, from the legislation. And lots of it just looks unnecessary, symbolic. The government has already got the powers to do quite a lot of the stuff that this is legislating for, but just isn't using them now. And so perhaps there's actually little reason to think that they'll start using them in future when they've got a sort of restatement of the powers that they've already got at the moment, if you see what I mean. So before I get stuck into sort of going through it, I'm a bit torn. I've made some notes so I could go through the entire thing, but it feels like a bad idea to go through all 55, I think it is, clauses individually. So I want to start with a bit of context and then whiz through some of the sort of key bits, and then we'll have a chance for more detailed questions at the end. So as context, I think it's important to remember that there are some serious problems in the asylum system at the moment. But the big standout problem is that there's a very long time to wait for an initial decision from the Home Office. So asylum seekers, whether they're genuine or not, are waiting for months and increasingly years for initial claims to be decided by the Home Office. And there's nothing in the legislation to address that. There's lots of stuff which effectively blames other people. It blames the tribunal, it blames the judges, and so on. It blames the asylum seekers, of course, but none of it actually addresses the real reasons that there must be for Home Office inefficiency. And those things aren't anything to do with legislation. They're not to do with an act of Parliament or setting the law. It's to do with basic bureaucratic management of the Home Office. You know, the number of staff in the asylum team has been going up, but their productivity has been going down. And to their credit, though, I think as context here as well, we should recall that the number of people who are actually getting asylum from the Home Office has been going up. It's about half of all asylum seekers. It's hovering around just below the sort of 50% figure. So a lot of people are actually winning their claims at the Home Office, which they're to be, you know, the Home Office is to be commended for. That's a far higher rate than in previous years. It was as low as 4% in the mid-90s. I was finding when I was doing some of the research for my book. So the tribunal, in contrast to the Home Office, already offers a rapid asylum appeal process. So the 3 months before the pandemic got going, the average was 25 weeks from start to finish, which is a lot faster than the Home Office. That's about 6 months, essentially. as context, I think it's useful to say and remind ourselves, and this is a bit counterintuitive, I think, because we've all been kind of programmed by the Home Office to think otherwise. But ultimately, the Home Office doesn't actually care, I think, what happens to an asylum seeker at the end of their case, whether they win or whether they lose. If they win, then the integration and the practical support is virtually non-existent, and there's all sorts of asylum seekers, recognised refugees at this point, who are basically being made homeless because there's inadequate transition from Home Office support to local authority support and so on. There is some support available, but it's not easy to access, and essentially the Home Office just doesn't care. The Home Office also doesn't care about people who lose their cases. Enforced removals peaked at about 20,000 a year or so in 2005, and they'd fallen to an historic low of just over 7,000 before the pandemic, and they're obviously lower than that during the pandemic period. And that's all removals. That's not just asylum seekers, that's all removals, including people who are being deported for having committed criminal offences and so on. So the actual number of asylum seekers being removed is much lower than that. And also voluntary returns have been falling year on year at the same time. And it does make me wonder why there is all this fuss about the process and the nuts and bolts of the system and so on, when basically not much happens at the end of it anyway. Although I think it's important to make clear that I am, for rhetorical purposes, perhaps minimising the awful impact that living unlawfully in the UK has. I mean, people aren't removed, they're not forced out, but they don't have lawful status, and that is an extremely uncomfortable life in the UK, but it's not sufficient to force them out or self-deport, as they say in America. The other bit of context to remember is that deterrent effect doesn't work. There's never been any evidence that it does, and even the Home Office impact assessment on the bill, which was published I think about a week ago or so, makes this point that deterrent effect, there's no evidence to support it. So essentially, being horrible to people doesn't stop other similar people from coming to the UK. And so, for example, throwing more refugees in prison achieves lots of use of prison resources, might get you a few good headlines, but it doesn't actually have any public policy impact on the number of people who are entering. So it's pointless from that point of view, yet at the same time, it also causes really serious suffering to those who are affected. Before we go any further as well, I just want to say that a lot of this pointlessness and, when it comes down to it, cruelty, I think, to those who are going to be affected, it's going to generate quite a lot of litigation. It's like a kind of lawyer's charter in a way. And I don't say that with any relish, because I'm quite disillusioned about some of the litigation that we see. As a lot of it ends up being largely pointless, doesn't achieve a great deal sometimes for the litigants. The Home Office is very reluctant to reverse judicial review decisions and things like that. But we're going to see the Supreme Court getting involved, if the bill goes through in its current form, we're going to see the Supreme Court getting involved on things like the correct standard of proof. There's going to be a big backlog of cases. There's going to be a lot of confused judges. There's going to be disputes over arcane language, compatibility with the Refugee Convention. That's good for the lawyers, perhaps. It's good if you want some judges to blame, to distract from the fact that you're not running your department properly. It might even be good for you, and I sort of say this a bit reluctantly, but if you're not a genuine refugee, if you are trying to pull a fast one, if you've come here and you're lying about what happened to you in the past and so on, because you're going to be stuck here for ages while the Home Office makes a decision. You'll be queued behind other people because of all the litigation about the new uncertainty in the system because of the changes and so on. And it's essentially very bad public policy. It's bad for trust in the asylum system. And it's a classic example of over-promising, but probably massively under-delivering as well. And it looks like an extended version of civil servants essentially trying to keep a minister happy with pointless non-reforms, while the minister has basically no idea of what is going on in her department and isn't getting on with the job of actually running one of the great offices of state. Okay, with that introduction done, I'm going to go through the 5 parts. I'm going to dwell on some parts of them, but not others. So I'm going to whiz through part 1 pretty quickly. Part 1 on nationality is basically broadly positive. Well, it's very good. In some parts, there's one negative part, which is that it removes, I'm not quite sure that protection is the right word, but it removes one of the facilities to enable stateless children to register, at least in some cases. And it's actually quite a lot narrower than I thought it would be, so it doesn't affect that many children possibly, but disenabling stateless children to become British doesn't seem like a very good idea, frankly, but that's what it does. The other provisions are basically about correcting nationality law injustices which flowed from sex discrimination, essentially. And we've seen that with successive bits of legislation where the Home Office has, to its credit, gradually, if only it could have done it all right at the start, that would have been better, but has gradually improved the situation and removed sort of historic gender discrimination, at least to some extent. It sometimes puts things right as if that the discrimination had never been there, but more often that it at least enables people to register if they want to become a British citizen, or sometimes it's a different type of British national. Registration isn't quite as straightforward as having things by right, but it's certainly better than nothing, and there's usually no fee attached to it. Okay, moving on to part 2, asylum. The first section of this, or sort of I don't mean section in the sense of section of a piece of legislation. When you talk about a bill, you talk about clauses. The first group of these clauses is on treatment of refugees and support for asylum seekers. And clause 10 is a really good example of what I was talking about at the beginning, where I say it's basically pointless legislation because the government already has the power to do this. So clause 10 formalizes the idea of differential treatment of refugees depending on their mode of entry. So a person who comes directly to the UK from a country or territory where their life or freedom was threatened and presents themselves without delay to the authorities, or has entered unlawfully and can show good cause, then they're treated one way, and it doesn't actually say how they'll be treated. It gives some examples, but they're not exhaustive, I don't think. And somebody who enters a different way will be treated in a different way. They can do that anyway. They are already doing that anyway. You just don't need legislation to achieve that. Unless it's because this breaches the Refugee Convention, in which case, if you were the government and you wanted to breach the Refugee Convention, you would want to legislate on this because it forces the judges to comply. Otherwise, the judges will be looking for a way around so that they could comply with international law. Arguably, it might breach the Refugee Convention. There's Article 3 on non-discrimination, which there's a sort of stretch of an argument. You might be able to say that there's violates that because it's non-discrimination on certain grounds, including nationality and mode of entry, sort of determined by nationality. And there's also some provisions on rights of refugees and access to benefits, which arguably this may breach as well. So that's, that could be, I suppose, a reason. It's certainly not what the government says in the explanatory statement. And obviously it's not a good reason for legislating to make sure that judges do have to act in breach of international law, essentially. I'm going to mention clause 10 I was talking about. Clause 34 is relevant here as well because it kind of reinterprets parts of the Refugee Convention. I'll come back to that if I've got time towards the end. Clause 11 on accommodation seems, again, pretty pointless. It's got some stuff about asylum centres and sort of reception centres, and it's clearly aimed at the kind of asylum camps that we've seen over the last couple of years. But there's already power in law to do that. So I'm not quite sure what it's about other than just making it look like they're doing something, because we've already seen Napier, we've already seen Penally. I'm not saying those are good things, but the government clearly has the power to do it at the moment. And I can say that from personal experience. My first job was at the Oakington Reception Centre near Cambridge in 2000, and I worked on site at a converted barracks, assisting asylum seekers and refugees with their initial claim to asylum there. So it's not unprecedented, this stuff. It's actually just already there in law. So I can't really understand why they're re-legislating on it. Clause 12 covers designated place of claim, and it's the same deal. It's something that's already in the immigration rules, and I'm not really sure why it's gone into the primary legislation unless it's really just about sort of satisfying the minister that something's being done, and it's kind of filling up the text. It's making it look like something's happening. The one exception to that on clause 12 might be that it seems to exclude asylum claims being made in UK territorial waters. Now that's arguably in breach of the Refugee Convention. It's arguably sort of in breach of the concept of state jurisdiction as it operates in international human rights law. But if you think about the practicalities, it's hard to see how that has any real world impact, because if somebody claims asylum in territorial waters, and you sort of stick your fingers in your ear and you refuse to listen to them, what are you then going to do? Are you going to disembark them in the UK anyway, in which case they can claim asylum there? Are you going to take them to France, in which case you need the permission of the French unless you're going to invade? Are you simply going to turn them back at sea and watch them float away, in which case you're in breach of international law of the sea and the duty of rescue and so on? So it's kind of, I'm not really sure there's much points to that, but that is, I think, a new piece of law at least. In that vein, again, on the kind of, the law is new, but it doesn't necessarily have any real world consequences. We've got a number of provisions on inadmissibility. So clause 13 covers inadmissibility of EU asylum claims, which was already the case anyway. I don't like to see this, and I don't like to see it in primary legislation because it, frankly, clearly breaches the Refugee Convention. The idea that you cannot claim asylum from certain countries, that's clearly in breach of the Refugee Convention, but it was already wrongly a feature of EU law, so it kind of just continues the status quo in a way. Clause 14 is on inadmissibility for those connected to a safe country. We've already got this in the immigration rules. We haven't really seen any legal challenges to that yet, and that's kind of putting into primary legislation this really daft system that we've already got under the rules, where you get put into a queue to go into the queue to have your claim eventually decided for asylum, unless there's an agreement with a third country, a safe country, where you can be removed there for them to deal with you. Now, if there were any agreements, then this would be really problematic. It would be about the UK evading responsibility to process, moral responsibility at least, to process asylum claims. But there are no agreements with a third country, so all that's happening at the moment is people are waiting for an extra 6 months on the beginning of their asylum claim before the Home Office even puts them in the queue to then decide their asylum claim. And this is essentially institutionalizing that in primary legislation as well. So it's, in principle, very objectionable. In practice, it has no real impact other than adding to the already considerable delays in the asylum system. There's then clause 15, which is on asylum support in those circumstances, and clause 26, I think, need to mention here as well, which with Schedule 3 allows for removal to a safe third country, which again, this is highly controversial in principle because it clearly breaches the spirit of the Refugee Convention. I don't think it breaches the letter of the Refugee Convention. The Refugee Convention probably does allow turnarounds as long as it's to an actually safe country. What you can't do under the Refugee Convention is send somebody back into a situation of persecution. If you're removing somebody to France, you're not likely to be doing that. So it's not necessarily in breach of the letter of the Refugee Convention. But if you start thinking about the practicalities, what country would actually be willing to receive asylum seekers from us? What would the arrangements be? Would those asylum seekers be detained to stop them resuming their journeys to the UK? Presumably they would be. What sort of conditions of detention would we be talking about? What kind of period of detention would we be talking about? And then you start to see that that's likely to engage human rights law. So not the Refugee Convention as such, but the European Convention on Human Rights. And judges are never going to allow removals if there's going to be a breach of Article 3 once somebody is removed as a consequence of that removal. So the practicalities of that seem pretty complex, as do the sort of moral implications of essentially turning our back on the international refugee system, which was agreed after the Second World War. There's a few clauses on submission of evidence. It's a bit of an obsession in this legislation. It comes up in clause after clause where basically asylum seekers are encouraged or required to give evidence, to serve notice of their evidence, basically at the earliest possible opportunity. And if they don't, then it will somehow be counted against them. And it's just the sort of premise that asylum seekers are putting in lots of late evidence and that nobody cares are both false premises. It just doesn't happen a great deal. And it certainly isn't causing delays in the asylum system. What's causing delays in the asylum system is the Home Office not making decisions. It's not, at the tribunal stage or anything like that. It's not about repeat claims. It's about the Home Office not even attempting to remove people in the first place. So there's quite a few clauses on that. Clauses 16, clause 17 on damage and credibility, unless there are good reasons where you submit late evidence. Clause 23, again, and it requires judges to have regard to the principle that minimal weight should be given to the evidence if it's served late. It's like the analogy that comes to mind is telling judges how to assess evidence is basically mansplaining or judge-splaining. It's objectionable in principle. There's just no need for it. It's utterly unnecessary. And the tribunal is fast and efficient, unlike the Home Office. So I don't know what that's about. It's just sort of performance, essentially. And it also, it's objectionable because what if there is some legitimate reason for late evidence? What if there's a coup in the country concerned? Should the person be disbelieved that there's a coup, even though they've got the news reports? But it's late evidence. I don't know. It just doesn't really make much sense. There's some nasty stuff on expedited appeals, and I think this is quite concerning. Although once I start to think about it, I wonder whether it really would have that much of a real-world impact. And this is a system called priority removal notices. So this is a notice that somebody gets served with, and the legislation says anybody can be served with it, basically. It specifically flags use for people who've already had a previous claim, but it doesn't limit it to those people. So literally, everybody could be served with one of these priority removal notices, although obviously that belies the idea of any of them being a priority. So we don't know how much this would be used, but the effect that it has is that you can't appeal directly to the first tier tribunal. You have to appeal to the upper tribunal, and then there is no onward right of appeal to the Court of Appeal, which is really bad news. That's just a really bad idea because it just gives you a single sort of unicameral appeal system. We've had that before. It was a really bad idea. And eventually it got scrapped by the 2007 legislation, the Tribunal Courts and Enforcement Act. But I think it doesn't oust the jurisdiction of the High Courts, which means that if the upper tribunal makes an error of law, which is the test for appealing to the Court of Appeal, if the tribunal makes an error of law, then it could be judicially reviewed in the High Court, and then there would be an appeal to the Court of Appeal from that, and then to the Supreme Court from there. So at the moment, you've got first tier, upper tier, Court of Appeal, Supreme Court, and instead you'd have upper tribunal, High Court, Court of Appeal, Supreme Court. And you end up thinking, well, what on earth is the point of that? And there could be it could be that there are some real problems with, it's not a full judicial review of the upper tribunal. It could be some sort of CART, lawyers will know the reference. It's kind of abbreviated papers only process or something like that, as we have upper tribunal permission to appeal refusals and things like that. So there could be some real problems there, but on the face of it, it just replaces a kind of 4 stages of appeal with a different 4 stages of appeal, where it's likely to be much more protracted, and you're not getting the sort of fast, efficient service that you get from the first tier tribunal at the moment. Although actually the upper tribunal, I think, will be mandated to try and decide these claims more quickly than the first tier would have done, thus putting everybody else to the back of the queue in the upper tribunal and annoying everybody else as well. So that looks like pretty bad news. And worse than that, though, is basically the reintroduction of a detained fast track by means of primary legislation. This is clause 24, and essentially overrules the detention action case from 2015, in which the previous system was held to be unfair on the basis it was systematically unfair and unjust. And the point of putting it into primary legislation is that the courts can't overrule an act of parliament. So it kind of mandates a fast track process. It wasn't previously embedded into primary legislation, but once it is, then it can't be overturned in the same way that it was back in 2015. So it looks like there'll be a detained fast track back again for appeals. But of course, it's not appeals that are causing the delays in the asylum system. It's the initial decisions from the Home Office. So again, it's hard to see how that directly addresses the real delays in the system, which are at the initial stage, not at the appeal stage. Clause 25 removes even out-of-country appeals for cases which are certified as clearly unfounded, which sounds bad, but I've got mixed feelings on that. It kind of, frankly, jettisoning the pretense that you could ever have a serious appeal from out of country is perhaps a good thing. And as the Home Office points out, there's still an application for judicial review within the country of the decision to certify. So perhaps it's just a bit more honest than the current system, where there's this pretense that people have got an appeal once they're removed, which in fact is extremely hard to pursue. There's a bunch of clauses. I'm going to finish in about sort of 5 minutes or so, I hope. So I'm just going to run through a few things fairly quickly. There's a bunch of clauses interpreting various different provisions of the Refugee Convention, which is generally speaking really bad idea from international law, because if you have different countries adding different interpretations, you end up with a convention being, which is supposed to be international, being interpreted differently in different countries. But a lot of the changes are actually basically the same as, or very slightly adapted versions of EU asylum law, just being incorporated into primary legislation here in the UK. So it's not actually changing all that much. And there are exceptions to that, but that's what most of this sort of bit does, clauses 27 to 33. Clause 29 is an exception. I despair a little bit with clause 29. This changes the standard of proof in asylum claims and creates a split standard of proof. So you have one standard of proof, which is the balance of probabilities now, if this goes through, for establishing past events and also establishing whether you've got a characteristic which might make you persecuted, which sort of sounds like it's aimed at gay cases, I'm not sure. And then there'll be a lower standard of proof for trying to establish future risk. That's the current standard of proof. So at the moment, we've got one system, which is the lower standard of proof, reasonable degree of foreseeability for establishing everything. But in the future, there'll be this higher standard of proof, the normal civil standard for establishing past events or whether you've got a characteristic which might lead you to be persecuted. The US does that, but that's the only country I'm aware of that does that. Everybody else in the world has always thought that's a really bad idea because it'll just confuse judges, leads to a lot of litigation. We'll have the Supreme Court having to pronounce on it. And it just probably won't actually achieve anything. It sort of looks like it will make things harder. And you think, well, having a higher standard of proof, that's got to be bad news. But I'm not sure it will really change the process of decision-making in asylum claims. And anyway, this will only apply in refugee claims. It won't apply in human rights claims. So you'd have somebody in the hypothetical situation where somebody doesn't meet the civil standard of proof for something, but does meet the lower normal asylum standard for something, then they won't be entitled to refugee status, but they still can't be removed because it would breach human rights law. And it's just crazy. It doesn't improve decision-making, which is what the explanatory notes say. It just makes a total mess of decision-making, and it's likely to lead to a lot of confusion and a lot of litigation. There's also some really bad stuff on criminal offences and penalisation. And as I said at the start, I don't think this is likely to have any kind of deterrent effect. There's never been any evidence that deterrent effect really works, but it is likely to end up with a lot of asylum seekers and perhaps some others going to prison, which is just really bad news. Essentially, it removes protection from penalisation for refugees. That's clause 34. And then also clause 37 penalises any refugee knowingly arriving without entry clearance or entering the UK without leave to enter. And that looks to be obviously in breach of the Refugee Convention non-penalisation provision, which is Article 31. We've also got clause 38, which has been very controversial. This is the one that removes the need for asylum. This is a penalty of assisting an asylum seeker, and it removes the requirement that the action be for gain. And that's targeted at smugglers at the moment, somebody who's doing it for gain, but that for gain requirement will be removed. And there's an issue around whether people who rescue asylum seekers at sea might thus be penalised. So it's the RNLI, private shipmasters, yachtsmen, and arguably this amounts to a breach of the law of the sea, because if you're disincentivizing a ship's master from conducting a sea rescue, then you're going to be in breach of several different marine conventions. There's some stuff on enforcement powers, and this is quite interesting. Adrian Berry's done a good blog post on this over on his website, and he's pointed out that the clause 41 and the schedule amendments that go with it basically allow immigration officers to intervene in foreign and international waters, so in French waters, for example, and for the purpose of preventing, detecting, investigating, or prosecuting a relevant immigration-related offence. And it includes turn-back powers to require the ship to be taken to any place in the UK or elsewhere, France, for example, if the French would allow you, or if you want to invade them, or to require the ship to leave UK waters, although how you're supposed to do that in the French Channel, I'm not entirely sure, without going into French waters. So that's interesting. And what's also interesting is that officials would be indemnified. So a relevant officer would not be liable in criminal or civil proceedings for anything done in the purported performance of these functions if the court is satisfied that the act was done in good faith and there were reasonable grounds for doing it. Which is interesting because clearly there could be criminal proceedings against somebody who's responsible for doing this when somebody then subsequently dies. There could be civil proceedings. So it's interesting that the government recognises that and has decided to indemnify its officials and prevent them from being prosecuted in those circumstances. How happy those officials will be about that, I think we need to ask the officials in question and perhaps their union. There's then Part 4, which I'm only going to touch on modern slavery, which is generally speaking not good news. It sort of toughens up the process, requires people to act in a timely way, penalises them if they don't. It reduces the recovery period from the current 45 days to 30 days for victims of trafficking, and it introduces this really weird bad faith requirement. So if you act in bad faith, you're disqualified from qualifying as a trafficking victim. But if you've acted in bad faith, then presumably you're not a trafficking victim and you'd lose your case anyway. So I don't really see what the point of that is. But then more importantly, it also basically excludes any person with a 12-month sentence from being treated as a trafficking victim, which is very bad news because there are people who have committed criminal offences who are also trafficking victims and they should be protected, and they're not going to be once this becomes law. Part 5 is slightly ominously from a legal point of view entitled Miscellaneous, and there are several what are called placeholder provisions here, which is where the government hasn't actually drafted legislation yet and doesn't really know what it wants to do, but it thinks it'll have a better idea by the time this starts going through committee, and it will amend its own legislation to be a bit more specific. So there's something on age assessments, which is placeholder, on visa penalties, which is essentially collective punishment for nationals of a certain country where other nationals of that country are breaching immigration laws. That's also placeholder, and there's also a placeholder provision on electronic travel authorization as well. So it's a bit difficult to comment on those because we don't know what the final version is going to be. And if you think that's a really funny way to present legislation to Parliament for approval, you'd be absolutely right. And if you also thought, well, Priti Patel's been talking about this legislation for literally years now and how great it is, and yet we actually see it and he doesn't even know what he wants to do, and you think that's funny, then I think you'd be right about that as well. Not funny, ha ha. Clause 62 covers wasted costs orders, which again seem rather pointless. It's not wasted cost orders, rather, it's more sort of wasted cost fines. So the tribunal, if you've behaved badly in litigation, at the moment you can already have a wasted costs order, which is where you have to pay essentially enhanced costs for the other side for them having messed you around and behaved badly. But this introduces on top of that a kind of fine which also gets paid to the tribunal. And it's hard to see that that's going to change anybody's behaviour because there's already what should be a substantial deterrent, which is the wasted costs orders. But the curious thing about this is that HOPOs become personally liable, whereas they weren't previously. So HOPOs are Home Office presenting officers, the people who represent the tribunal in court, and it seems to more or less explicitly make them personally liable, which I imagine they're going to have something to say about, and it probably means that they'll have to be indemnified by their employer. But how that it's surprising, shall we say, to see the Home Office introducing that. Arguably, could be seen as good news, I suppose, because a lot of the delays, in my own experience, a lot of the really bad litigation behaviour is by the Home Office, where they just haven't done what they're supposed to do, they haven't responded to directions, and it causes delays with hearings. So perhaps that will discourage that behaviour in future, I don't know. There's also clause 64 on good faith. Apparently the Home Office will have to take into account whether a person has acted in good faith, because previously nobody ever thought about that or something. Again, really daft bit of legislation. And then clause 65 is incredible, basically. It's a massive Henry VIII power, as some people call it, where basically it enables the Secretary of State to unilaterally change primary legislation, any immigration primary legislation, as long as it's with a view to legislative consolidation and preparation for simplification of immigration legislation. That's a massive power, and I imagine that that's something that's going to be hotly debated in Parliament as it goes through, because it gives the Home Secretary huge authority to adapt immigration laws without having to go through a normal parliamentary procedure to do so. Okay, so that took a bit longer than I planned, but I did manage to get through more or less everything. And I'm very happy to try and answer questions on any of that, or at least sort of direct you in the direction of an answer, because it might be that if you've got very technical questions, I'm not in a position to immediately answer them.
Thanks, Colin. That's like, I keep thinking, firstly, what a mess. Secondly, thank goodness this was being recorded, because there was so much information in there.
Yeah, I'm sorry about that.
No, it's great. It's really, really helpful. So thanks. So I'm going to put some of the questions in the Q&A to you, and maybe give them a bit of a spin for myself as well. So there's a couple of questions first about reformal. So one from Raphael asking whether the proposed new powers for UK Border Force to direct vessels out of UK territorial waters and return people to safe countries risks undermining the principle of non-refoulement. Now, I realise you kind of sort of addressed that, but I think the question is about undermining the principle rather than would it technically count. And then relatedly, Nicola saying that she's that the UK is already sending Zimbabwean political dissidents back to Zimbabwe, but yet this isn't being called reformal. Can you kind of explain that?
The first question first, Raphael's question. It depends where you're sending somebody to. So there is a risk of breaching the principle of non-refoulement if somebody gets sent to a country where they're going to be badly treated. So it depends who the agreement is with. If it's with the French, then, and we all know that the French police aren't terribly friendly to refugees, to put it mildly, shall we say. There's all sorts of problems with, like really serious problems with the policing of asylum seekers on the sort of British-facing coast. But it's probably not persecution. And certainly there's been no litigation that I'm aware of anyway in France that's proved that it is. And so an agreement with France or with any other EU country is essentially no different in principle to the Dublin Convention and Dublin Regulation that we were part of until recently as part of the EU. If the agreement is with another country, all sorts of countries get postulated, perhaps in Africa. I think at one point the Cabinet Office was leaking something suggesting South America. That's pretty wacky idea. You take somebody who've arrived across Europe from Afghanistan or from Iran and via France, and then you'll send them off to Mexico or something, and they might end up in the United States. The United States might not be very happy about that. I don't know. But if it's to another country somewhere else where they will be badly treated, then obviously that does breach the principle of non-refoulement. So I think a lot turns on the practicalities. I know that's not a very principled answer, but I just, given that we've been part of the Dublin arrangement until now, it's hard to say that people being sent back to Europe is a big problem. Although, of course, we have seen litigation like the MSS case, I think it is, isn't it, against Greece and Belgium, where because the Greek system had broken down so badly and things like that. So I know those protections, I guess, would still be in place. You'd still be able to litigate that, I would have hoped. I don't see it. This excludes that from happening. The other question on Zimbabwe, I just don't know anything about that. I mean, if that certainly shouldn't be happening. If somebody's got an asylum claim, they can make it and they can try and prove it. The asylum system is very much imperfect, but it's a lot better than it used to be. Almost half of claims are being accepted by the Home Office, and then almost half of asylum appeals are actually succeeding as well. But there are protections against being sent to somewhere like Zimbabwe if you are a political activist, because you can make an asylum claim here. I haven't heard of sort of people being bumped without the opportunity to make a claim or anything like that, if that's what the question's about.
Thanks, Colin. There's a question from Paolo saying, great point about the uselessness and lack of effects of the bill. In your opinion, which is the best explanation for this? Is it that whoever drafted it is not very clever? is it that it's producing a docile labour force, or is it that the bill is preparing the legal ground for further reforms? And I'd like to kind of supplement that way, because I too was thinking, you know, when you wrote in your blog post a few weeks ago about how actually a lot of this, nothing very much has changed. And I wondered, and then sometimes the changes actually, there are substantial changes, but they don't affect very many people. And I was wondering whether there are kind of, whether you have any concerns that there are points where what's actually being brought in is principles, is the thin end of the wedge, and if so, what would you highlight?
Those are really good questions. I don't think whoever drafted it isn't very clever. I mean, it's drafted by parliamentary draftsmen. They're clever people, but they do what they're told, basically. And I think they've been told to come up with some stuff, just stuff. You know, it doesn't have to really have any real world consequences, or that's one possibility, or that civil servants are under pressure from a minister and this is all they can come up with, basically. I don't think anybody at the Home Office, anyone as serious at the Home Office, or any of the people responsible for drafting this will really expect much of it to have much real world impact. Maybe Priti Patel does expect it to have real world impact. I don't know. Maybe she's had the wool pulled over her eyes by the people responsible for it. Or maybe she realizes as well. I don't know. But I don't think it's likely to be about the sort of thin ends of the wedge type arguments. I don't think it's so cunning as to create a kind of staging ground for further reform. I think if they wanted to do the further reform stuff, they'd just do it. I just think they haven't got any ideas. The problems in the asylum system are at the Home Office, and they can't admit that because that's basically admitting their incompetence. And so they're looking to blame other people by legislating to make it look like it's somebody else's fault. And it's kind of, it's the opposite of what we saw with some of the previous legislation. So if you look at something like the Immigration Act 2014, 2016, Theresa May, she was a serious politician, really awful politician, but a serious one. And she didn't legislate quickly. She waited 4 years before the Immigration Act 2014 became law, although it was introduced in 2013. There was a quite delayed process going through Parliament. And then the changes really counted. They really had an impact. And they were horrible changes. They had a really nasty effect. But you couldn't say that they were window dressing or ineffective or anything like that. Whereas this goes back to some of the kind of Labour era reforms. Not all of them. I mean, there were some major changes made under Labour in the kind of 2000 to 2007, 2006, 2007 kind of period. There were major changes to the way that borders operate, to export of British borders abroad and so on. But a lot of the other changes that were introduced by Labour were essentially performative. They were never implemented. They were about making it look like you were doing something. And I see this as a kind of return to that, where you're kind of talking tough, you're raising expectations, and then basically you're not really changing anything on the ground because you're not getting on with the business of actually managing your department properly. So I don't think it's necessarily sinister. I'm not trying to say it's good. It's not. This is good, but it's not necessarily as sinister as that, I don't think.
But there were some times when, so sometimes you said, well, that something would be in clear breach of the convention. Sometimes you said it might be interpreted as being a breach. So this, I suppose, there's just a question that comes up that I think is germane to this, which is from Asylum Matters, who say, what would the legal consequences of breaching the Refugee Convention be for the UK government? Yeah,
that's a really good question, because it sounds great when you say, well, that's in breach of the Refugee Convention, but there's no enforcement mechanism for the Refugee Convention. There's no international court of refugees where countries can be held to account for their breach of the Refugee Convention, their breach of non-refoulement principles and things like that. And so the immediate consequences of breaching the Refugee Convention are generally zero. It just doesn't have any impact for a government. The idea of an international convention is that when you sign up to it, you agree that you're going to implement it in good faith. Other later conventions, later human rights conventions, have more effective implementation sort of provisions and supervision provisions. And the Refugee Convention was one of the first conventions after the Second World War. So later human rights conventions have got committees attached to them, they've got supervisory bodies, or they've even got courts attached to them as well. But the Refugee Convention just doesn't have those things, and it's unlikely that they're ever going to be introduced because so many countries enjoy breaching the Refugee Convention these days. There can be consequences on an individual level. So the Refugee Convention has never been properly integrated into UK law. It's sort of integrated. It's kind of reflected in the immigration rules. There is an Act of Parliament which says that the immigration rules can't be incompatible with it. That means that, for example, if you bring an appeal and you've got a right of appeal and you bring an appeal on the grounds that you're a refugee, then judges will, generally speaking, apply the Refugee Convention, subject to these Acts of Parliament which tell them how to interpret certain things and so on. So yes, we've got a proper refugee status determination process, but if the government breaches it, for example, by rewriting the interpretation of the non-penalisation clause, Article 31, something like that, then there's no international consequences for the government. UNHCR can complain about it, can make a big fuss about it. Lots of people can get really cross about it on Twitter, and that's about it, basically.
Oh, depressing.
Yeah.
There's a couple of questions about the nationality provisions that I'll ask you. So one from Joe, he asks, have you noticed the nationality provisions of the bill do not address issues of surrogacy, and these have been ignored for a long time? Am I right in thinking that those with precarious immigration status in the UK have a right to private life and start a family in the way that they may prefer? And then another question about the nationality. Historically, Labour have not been supportive of the amendments put forward in the nationality section of the bill. These are the amendments they had continually refused when they were in government. Why do you think this is, and who will be holding them to account? Do you think the nationality section has missed any group who's currently experiencing citizenship and nationality discrimination?
So if I take the first question, it's a good point actually about the failure to address surrogacy. I think one of the sections, thinking about it, one of the clauses might have some effect there, which is the definition of parent. Because one of the problems that I've seen come up in surrogacy cases is that where the surrogate mother is already married to somebody else, then that father is automatically in British law the father. And so there's all sorts of problems. Basically nationality isn't transmitted in those circumstances. And I think that is partially addressed with one of the provisions which allows registration in those circumstances. So it's not an automatic transmission of nationality, which would be better, but it does allow for registration. So that might actually deal with that's a fairly common problem in surrogacy cases. Because I think especially in the United States, the surrogacy agencies often prefer married women, I think, for some reason. It's been a while since I've done any cases, but I remember that being a problem in several cases. So it might be that actually that is addressed to some extent. And the point about precarious immigration status and the right to private life, I agree, but it's not something that's really covered in the legislation. It's not addressed in the legislation, either sort of positively or negatively, I think. On the question about Labour not being supportive of amendments, I'm slightly surprised by that. I think and a lot of the reform process for the gender discrimination stuff and undoing some of the divergence between citizenship and nationality that took place after the 1962 and 1968 Acts, that was started in 2002 under Labour, and it's been a process of it's been very incomplete. Each time there's been people who've been left behind, but it's been gradually getting better over time. And it's been a feature, I think, of successive legislation, I think, including under the previous Labour government. And to the credit of successive governments, they have gradually begun to deal with that and to recognise the injustices that were done, although often only with allowing registration, which is essentially a type of application, rather than automatically entitling people, which would be better. I can't think of any groups that have been missed, I'm afraid, but that's not to say that there aren't some. I'm trying to pick through who has been essentially shafted by British nationality law over the last sort of 50 years is quite difficult. There was, and it's longer than 50 years because of the kind of knock-on effects that previous legislation has on the latest legislation and then on the latest legislation. But I'm not aware of any further groups, but there probably are some. And of course, the remedies that are being offered here aren't ideal, but they are something at least, and it's registration rather than as of right.
And then there's some questions about arrivals. So from Nicola, one hears that no spontaneous arrivals will be able to claim asylum in future, only resettlement allowed, but one also hears it depends on how you get here. Please, can you clarify? And then from Tom, will people be granted lesser temporary protection status because they've passed through a so-called safe country, have no recourse to public funds? And then finally, does clause 37 reverse the Fuad Kakai, I'm sorry, I don't know how to pronounce it, Court of Appeal decision making arrival rather than entry an offence, i.e. will this allow the CPS to continue prosecuting asylum seekers who steer boats across the channel?
Yeah, those are all good questions as well. On the first one, I don't think it's right, unless I've misunderstood something as I've been going through the legislation. I don't think it's right that spontaneous arrivals won't be able to claim asylum. So they will be able to claim asylum. And I think it can't be right that that's the case, that they're stopped from claiming, because a lot of the legislation is aimed at treating them badly and giving them worse status after their claims have been processed and they've been found to be refugees. So I think that presupposes that they are actually able to claim asylum and get asylum, but just less good asylum. And so I don't think it's stopping people from claiming, but it is treating them badly and differentially on the basis of their spontaneous arrival and their sort of illegal entry, essentially. So that's that first one. Tom was asking about lesser. I'm not sure about that.
NRPF, yeah.
Yeah, right. I'm not sure. I'm not sure if it's in the legislation itself. It would be unsurprising if that were to happen, but I wouldn't normally expect to see something quite that specific in primary legislation. So normally you wouldn't have the conditions to be attached to a visa set out in primary legislation, because it reduces the discretion for the Home Office, essentially. Although being horrible to people, they don't mind having that sort of embedded into legislation, I suppose. But they just don't need it to be in legislation. They can do that anyway. So I think we would expect that to happen. I think that's been part of the new plan for immigration or whatever it's called. But I don't remember seeing that specifically actually in the legislation. That's not to say that it's not, but I don't remember seeing that as I was picking through it. But I think that is going to happen though, but just not, it doesn't need to be in the legislation. And then the last question, essentially, it does reverse it, the Kakai case. It does reverse it in the sense that it doesn't change the text of that particular offence or adjust the text of that particular offence. It basically gets rid of that offence and replaces it with a different one, which is far worse and where there is no exemption. So I'm slightly to my surprise when I was trying to help the barrister with this. I think a few people were doing more than I was, but was sort of trying to pick through how the legislation worked, and it turned out that it was actually quite nuanced, and the CPS was clearly wrong to be bringing these prosecutions. And actually the way, and it's not often that you see immigration law well constructed, but it actually seemed to be fairly well constructed. So all that's going, obviously, and it's being replaced with this sort of basic arrival offence instead. So yes, the overall effect is that it reverses it, but it's not by tweaking the wording or something. It's by just completely replacing the offence with a new one, essentially.
And then there's a couple of questions about detention, broadly understood. So Sophia asks whether you could explain in more detail the detention provision for persons appealing negative first instance decisions. And then a question about offshore processing centres and whether the bill gives power to do this.
So there's not a lot in the legislation on detention. There's something on detained fast track, which suggests that detention will be used more extensively, and but it's not sort of direct in that sense. There is also a provision, I've just been looking through my notes that I was making beforehand, there is a provision specifically on immigration bail, which requires a judge considering bail to have regard to the fact that somebody has basically breached their conditions or failed to, I think it's failed to cooperate with their removal. But I don't think there's anything much else on detention, actually. There's also the stuff on asylum centres, and to my shame, I suddenly realised that I'm not quite sure whether those are necessarily closed or not. I imagine they probably are. But one of the alarming things we've seen with Penally and Napier is that they're not technically detention centres, because supposedly they're not locked, and asylum seekers aren't physically prevented from being from escaping from them or from leaving them. It's just that that's where their accommodation provided by the Home Office is, and so they haven't got anywhere else to go. But also there's been a lot of press reports of people literally being physically restrained there, being taken back there forcibly, and the gates being locked at night, which sounds a lot like a detention centre. So it's kind of almost quasi-official or unofficial detention. So I'm not, it's a good question actually about whether the sort of envisaged expanded use of those kind of asylum camps actually requires detention, or whether it would be that more kind of quasi halfway house kind of thing of Napier and Penally, where it's kind of detention by circumstances rather than sort of outright kind of barbed wire fences and things. So I think that's the only stuff that I can think of covering detention. I don't think it particularly covers detention for those appealing first instance decisions specifically. I don't think there's anything specifically on that.
And offshore processing.
Yeah, I've been kind of ignoring those as a distraction, which is I think a slightly weird thing to say. I'm a lawyer. There's not much I can necessarily do about offshore processing. I tend to be more worried about the stuff that's happening here in the UK. But the other reason that I've been ignoring them is that they just don't seem like they're going to happen to me. And there's a lot of fuss about them. There's a lot of press releases, but I think we've seen over the last few months that there's no realistic way forward to them actually being implemented in real life. Now, I could easily be wrong about that. And, it could be that in a year's time or 2 years' time, suddenly there's an agreement signed with Rwanda or somewhere in North Africa or something, and we really do start shipping people out to some desert detention centre where they rot away like the Australians have been doing on Pacific Islands. But it just doesn't seem to me like a viable possibility at the moment. And if that was to start happening, we do, at the moment at least, have the European Convention on Human Rights, which would prevent removals into that kind of appalling situation. The Australians, their legal system's different. They don't have that kind of ECHR regional framework, which prevents that kind of stuff from happening. We do have that at the moment. Now, obviously, if I was to be proved wrong on both of those things, that is deeply concerning. It's a real problem. And it's one of the problems with advocacy on the bill. It's like, it's not a very powerful advocacy point to say, this is terrible, but it's also pretty pointless. You're sort of really undermining your own argument by doing that. And I don't have a particularly good answer on how to get over that and sort of make an effective advocacy point on something that's really not likely to have that much real world impact and is therefore pointless. And then somebody says, well, why not just let us do it then? And it's the same with the offshore processing things. By sort of focusing on the practicalities and so on, I think I'm ignoring and I'm ignoring principled arguments about that being a really, really bad idea. And it is a really, really bad idea. It's, you know, the idea that you evade your responsibilities under the Refugee Convention, that you torpedo the idea of international solidarity and responsibility sharing for refugees by doing that sort of thing. I think it's terrible for all those reasons, but at the same time, it just doesn't at the moment seem very likely to happen. So I'm not that excited about them.
Well, that actually gets us neatly to, I think, a really important question from Harry. Do you have any sense of what amendments may be made as the bill goes through the committee stage? Are there any particular amendments refugee support groups are pushing for?
I don't know. It might be that I'm getting a bit more closely involved in the committee's work in the near future, but at the moment I just don't know. And I don't know how to find out either. The passage of laws through Parliament is a bit of a mystery for those who aren't sort of directly involved in it. And it's quite hard to find out what amendments are being pushed, for what purpose, by who, and so on, unless you're quite closely involved with it. So I'm afraid I just don't have an answer on that one. I'm
just trying to pick questions that are slightly different. So a question from Parveen: will those who have a lesser form of protection be entitled to family reunion, or will their family members come under a different part of the immigration rules?
It's not in the legislation. So, but again, you wouldn't expect it to be, because it's immigration rules that govern that. The Home Office can change the immigration rules very, very easily using what's called the negative resolution procedure. All they do is they have to lay new rules before Parliament. MPs can object, but even if they object, the rules still come into force anyway. And it's a really weak sort of form of scrutiny. And certainly the legislation allows for it, but it's something that could have happened anyway. So that, I think it's clause 10, wasn't it, which is on the differential treatment of refugees depending on their mode of entry and so on, certainly allows for that possibility. I think it might even specifically refer to it being enabled, but it was never needed anyway. It's something that they could have done in any event. So the answer is sort of, I think the answer is yes, but it doesn't need to be in the legislation, and it never actually needed to be in the legislation anyway. They could have done it if that's what they wanted to do.
And then an interesting question from Annika, asking, in terms of clause 38, assisting, does this only seem to apply to arrival, or could it be applied to organisations that support people who have been refused?
That's a good question. I don't think I'll be able to open it up on my computer quickly to check the wording. I think it does. I think it applies to a person assisting an asylum seeker breaching laws. I think it does probably apply to both. I've never seen it being used or it being suggested that it be used against somebody else. But I think it might be broadly enough drafted that it is. It's worth looking at the exact wording of what it is at the moment, checking the kind of amended version, the removal of the "again." But yeah, without having the exact text in front of me, I don't think I can quite sort of multitask to that extent. I can't give you a straight answer on it. It's a really good question, actually. I don't know the answer.
Yeah, that would be very alarming.
Well, it wouldn't be a change. It would be that would be something that was already the case. It's just that I've never noticed that myself. And possibly the Home Office has never noticed it either. I'm not sure, or they've just got no interest in prosecuting at the moment. But once you remove the "for gain," perhaps that broadens the terms of it, and it could be used more widely. Yeah, it's interesting. I don't know.
A question from Yasha: is the idea of prior permission to travel liable to stop or make it difficult for people being able to travel abroad, even if they're British or EU citizens? I'm not sure I quite understand that question. Do you understand that question, Colin?
No, I'm not sure I follow that one. I think it might be linked to the ETS provision, but I haven't, ETA. So that's clause 60 on electronic travel authorization. I haven't looked at that in detail because it's just a placeholder at the moment. I saw, I think Anne Singleton had been doing some work on this with State Watch, and they've been looking at it in more detail and really don't like it. but it's not something that I have to say I've looked at very closely yet.
Okay, and the last question, because we're already over time and I don't want to exhaust you. Of all the new powers included in the Act, which do you think is likely to prove, 1, the most used, 2, the most dangerous, and 3, the most contested?
That's a really good question to end on, and it's a really difficult one. I think probably the most dangerous is the prosecution of refugees, and I'd expect that to see that very widely used at the start. And when I was reading the legislation, and again reading it again and again, I was thinking, well, surely they can't be serious about this, because it would literally be prosecuting pretty much every single asylum seeker who arrives in the UK, and there are 30 to 35,000 arrivals per year, and that's a lot of people going to prison, and that's a lot of resources. You know, you're going to be rushing people through magistrates' courts a great deal. We saw something not dissimilar with the, I think it was the 2004 Act, wasn't it? Where there was the documents offence that suddenly a lot of people were getting prosecuted for and getting quite substantial prison sentences for as well, before it was kind of almost interpreted out of existence by later litigation. But what purpose, you have to ask, what purpose does that serve? It sends the refugees to prison. They've still got to decide their asylum claims, have still got to decide their asylum claims afterwards. Obviously, it's really unpleasant for the refugees. Probably doesn't put anybody off coming anyway, though. And so you'd expect to see usage decline, because just the resources that would have to go into that are so huge, and the number of prison places you'd have to build and so on, when we're already sort of over capacity as it is. So it seems like that could be the most used to begin with. Certainly, I think the most dangerous and most unpleasant part of it. Or the most used, possibly the detained fast track. You know, if we see another detained fast track, I think the Home Office would be quite keen on using that. There are constraints on it, because just simply the capacity of detention centres is much lower. The detention estate, as it's sometimes called, the immigration detention estate, is actually much smaller than it used to be. A number of places have been closed down over the last 10 years or so under Conservative governments. So it's actually a much smaller detention estate than it used to be. So there is a capacity issue there in terms of the number of people that get exposed to it. But if it's working for the Home Office, I think we'd probably expect to see that expanded. So again, that might well end up being something like the most used power. The most contested, I don't know. In terms of just the disproportionality of the purported gain for the Home Office versus the massive inconvenience and side effects, I think my money's on the standard of proof stuff, where I really don't see the Home Office gaining very much from tinkering around with something like the standard of proof, but it would have an effect in literally every single refugee claim, and judges are going to be very confused about it. There'll be loads of litigation for years trying to work out what it means and how it's applied in practice, and it probably doesn't really have much of a real world impact. So in that sense, I'd say that was going to be sort of very heavily contested, and perhaps going behind what I've just said about the detained fast track may be realistically the most used, because as I say, it applies in literally every refugee claim. So I think I've probably given you about 2 for each of those. I'm sorry about that, but those are my kind of least favourite bits for those reasons, I think.
Oh, thank you very much, Colin. That's really helpful, really interesting. And if I was cruel, we could go on for another hour. Apologies to those people whose questions we didn't get round to answering, but we just had so many questions, so sorry about that. And yeah, thanks a million, Colin. This is a clap from everyone I know, and keep up the good work. And really, everyone should take a look at your book, and also look at the Free Movement website and consider becoming members. I think you'll find it really, really helpful. So thanks a lot, everyone. Bye-bye.